Mr. Speaker, speaking of the resolution.
The delegate has the floor.
Mr. Speaker, members of the House, just quickly about what this is about. I want to remind everybody what this is about. And I talked a little bit about the legislative history of how the felon disenfranchisement got into the Constitution. So in 2006, we heard arguments when the Marshall-Newman Amendment got into the Virginia Constitution. And they said things like that same-sex marriage was unnatural. It would have deleterious effects on children, that would stigmatize these families, that they couldn't grow up healthy and happy. And so I just want to share briefly my own experience in my family with same-sex marriage, right? Because, as many of you know this, many of you heard me talk about this before, but my sister-in-law is married to a loving woman, and they have two fantastic, well-adjusted, successful children, my niece and my nephew. And we attend family gatherings together. And we have ever since my children were infants, before they were born. So they've never known any different. And they don't see any problem at all with having their aunt, with having their cousins have two moms instead of a mom and a dad. And my two nieces and nephew, they know that they have a mom. It gets a little confusing sometimes which mom they're talking about. But other than that, it's been a perfectly normal, healthy, fantastic, loving, and supportive experience for them. And they've had a wonderful life. So all the things we talked about, all these parade of horribles we hear about, could go away. It didn't happen. And why is it important now? Why is it important that we do this in the Virginia Constitution? Why do we have to get this out? Because as Delegate from Fairfax said, there are folks on the Supreme Court right now today that think we need to go backwards, that think that the federal protections that we have gone too far. And if you think any precedent in the federal Constitution that protects individual rights is safe, I would remind you just to look back a couple of years when fundamental rights that have been secured for 50 years in this country were overturned in a single decision. Not a progressive whittling away, nothing like that. Just in one fell swoop, one decision, 50 years worth of what we thought were settled rights went away. And so if you think that some settled rights that are only 9 or 10 or 11 years can't be overturned by this Supreme Court, which is set out to work its way backwards and take us back to a different America, then you're sorely mistaken. So we need to do this in Virginia. I have clients in my law practice that own title as husband and wife, tenants by as spouses, as married couples, as tenants by the entirety. What do we do with all those folks that bought property together as a married couple if Obergefell is overturned? What do we do with all the people that adopted children if Obergefell is overturned? What do we do with all people that set up their businesses, their trusts, their estate plans, assuming that they would always be viewed as a married couple if Obergefell is overturned, this Marshall-Newman Amendment snaps back into place, and everything we've done in Virginia, every law that we've passed that recognizes these loving unions is erased by our state constitution. Mr. Speaker, members of the House, you can argue over a point here or a point there. I wish I had said it better this way. But let's not forget what this is about. This is about families in Virginia. It's about loving families, about supportive families, about people that plan their lives around certainty, as we heard, and the importance of having that certainty. The way we give those families the certainty they need is to pass House Joint Resolution number 9. Thank you, Mr. Speaker.
The delegate from Princeton.